All jurors are present and accounted for, Judge. Welcome to be seated. Welcome back. We're going to continue this pivot point in Mr. Rucker's direct examination of Mr. Dickerson.
Got to pivot back very, very briefly, and then I'm going to pivot to a new area. But before I move on, let me ask you just a couple of questions, Mr. Dickerson. During the conversation in Mr. Maples' office, when you had the discussion about the bonus, the monies to Mr. Howard, did you get the impression from the defendant that he was joking about that?
No.
Can you tell the jurors what did you say to him specifically to clarify what he meant?
We answered this is now third.
Okay, the first question you asked, one, there was no objection, but that seemed like a new area, but I'm recalling at least 2 times.
Did I ask him what he said? Okay,
Yeah.
that's fine. Did you discuss a specific amount of money
No.
with the defendant? Why not?
I don't know why we didn't discuss a specific amount of money, only that an overture to the district attorney had not been made.
By whom?
By me. And I didn't know if the district attorney would respond to an overture. And so it seemed to me premature to talk about a bonus or success fee related to reducing or eliminating the charges.
I'd like to show you an exhibit, Your Honor, marked in the State's Exhibit 521. I have given defense counsel an opportunity to take a look at it. Can you look at that exhibit, Mr. Dickerson, and tell the jurors you recognize and you identify that exhibit?
Yes, sir. These are checks written to my firm.
Okay, by whom?
The estate of Diane Smith Mciver, Claude L. Mciver III, executor.
Okay. And those were checks that you received as payment for the services to the MacGyver defense team?
Those were some of the payments, yes.
Okay. Because how many checks are listed on that exhibit?
3?
3. Okay. I will attend the State's 521, Judge and evidence.
Any objection? Admitted.
You'll come up right here. And here on the top left corner, the check is drawn on what account?
Estate of Diane Smith Mciver, Claude L. Mciver III, executor.
And it's actually made out to your company in the amount of $3,000.
That's correct.
What is the date of this check?
January 23rd, 2017.
It's about 20 days or so after you signed your actual contract with Mr. MacGyver, correct?
Correct.
And you recognize the signature on that check to be his signature?
I do.
Can you tell the jurors what's the date of this check?
April 1st, 2017.
Also made out to your company
Yes, sir.
in the amount of $1,500.
Yes,
Also drawn on the estate of Diane Smith MacGyver.
that's correct.
And this third check, what's the date of this check?
April 25th, 2017.
Also for $1,500
Yes, sir.
made out to your company
Yes,
from the estate of Diane Smith MacGyver, correct?
correct.
Pivoting. Can you tell the jurors, after this conversation with the defendant, did you make an attempt to actually contact Mr. Howard?
I did.
And can you tell the jury, when did you do that?
Within days of our initial conversation and the agreement with Mr. Mciver and his attorneys that that was a strategy that they wanted to pursue.
Okay. And so we can be clear, what was the strategy that you were to pursue by contacting Mr. Howard?
To seek reduction or elimination of the current charges, the charges at that time.
Okay. And can you tell the jurors, did you have any intention in your mind that if you contacted Mr. Howard about a reduction in these charges, that you would communicate to him that the defendant was willing to offer him money to make the case go away?
No, no.
How did you attempt to contact Mr. Howard?
By text message.
And can you tell the jury, what did you say to him?
I'd like to talk to you about a new client.
Okay. And you can't tell us what he said because that's hearsay, okay? But let me ask you this question. Did he respond to your text message?
Yes.
Okay. And what did you say back to him after he responded to your text message about wanting to talk to you about a new client?
I told him who my new client was.
And who did you indicate your new client was?
Tex Mciver.
And can you tell the jurors, did you receive a response from Mr. Howard once you said to him that your new client was Tex Mciver?
I received no response at all.
No response. Is that kind of like sometimes my
Objection, whatever.
He knew it was going to be good too, didn't he, Judge? He knew it.
Guess I'll have to wait.
I'll have to wait. That was pretty good, Mr. Samuels. Okay. Can you tell the jury, from that day to this day, have you ever received a response from Mr. Howard in regards to discussing your new client, Tex Mciver?
No.
Can you tell the jury, did you communicate that to the defendant?
Yes.
What did you say to him?
He hasn't responded. He's not responding, and I think that that's instructive. I think that that's says a lot.
And what do you mean by that? When you were telling that to the defendant?
What he said is what's relevant, not what he meant. The witness. I'll let, you can repeat the question or something close to it. You
Okay.
can answer it.
Okay. When you said that to the defendant, were you trying to communicate something to him?
I was.
And when you say that the fact that you did not have a response back from Mr. Howard was instructive, what does that mean?
Your Honor, again, I'm not quite sure. I mean, we can speculate all we want about what he meant. The question is, what's in this regard here, and what did he?
Okay, well, we don't have to speculate as to what he meant because he's being asked what he meant. I'm going to let him answer the question.
What did you mean when you said it was instructive that you did not receive a response from the DA?
I meant to inform the client that the DA is not going to engage with me on this effort, and that was an intentional thing, not an oversight.
And can you tell the jury, when you said to Mr. McIver it was an intentional thing, why did you say that to him?
Well, he did say, he said, he already said what he said, now he's telling us what he.
Right, so let's not
Okay,
blur the
all right.
lines here.
Okay,
I'll
okay.
let you have him explain what he meant, but if that's not what he said to Mr. McIver, then
Okay, I understand.
use different words.
I understand. What did you say to Mr. McIver?
Asked and answered. He's already asked that.
Completely. About what happened when you attempted to reach out to the DA to communicate to him a possible reduction or dismissal of the charges.
We're not going to get Mr. Howard to engage on that effort. It's not going to happen.
What was his response?
Disappointment? Try again?
Did you try again?
I did not try again. I got the message loud and clear the first time.
And the message that you got loud and clear was from whom?
Mr. Howard.
Can you tell the jurors, after this, was there any other conversations about an exchange of money to make the charges get dropped or dismissed during any time that you were engaged with the defendant?
I don't recall any other conversation other than the initial one, which...
Okay.
Can you finish the sentence? Which?
Okay.
Did you have anything more you wanted to say, or were you done with that?
I don't recall any other conversation other than the initial one, which I think I had answered very definitively for Mr. Mciver, that I wouldn't do such a thing.
Now, can you tell the jury, did there come a point in time that you were no longer working for Mr. Mciver?
There became a point in time when I was no longer working for Mr. Mciver.
Okay. And can you tell the jurors, if we've got this check here, April 25th, 2017, can you give us a time frame under which you would no longer have been working for Mr. Mciver?
I was informed at a court hearing. It was the first court hearing at which Mr. Harvey was present as...
Your Honor. Caution the jury. Before you approach.
Sure, well, you can approach, but first, we make sure, Mr. Rucker, that Mr. Dickerson isn't about to relay something that's not relevant, but I think more on point. He was informed, unless he was informed by Mr. Mciver, then we could be getting...
I got you.
This area. Do you still need to approach or recover?
I understand, and if you would just grant me a tiny bit of leeway.
I need robes to grant anyway, but I had to...
Okay. There was a court hearing in which Mr. Harvey was present.
Correct.
Okay. And you had a conversation with someone.
I did.
And don't tell us what the person said to you, but can you tell us who did you have the conversation with?
Tammy Johnson.
Who did you understand Tammy Johnson to be in connection to this case?
An assistant or someone managing the affairs of the estate of Diane Mciver, but also an assistant to Mr. Mciver.
Okay. Now, after you had the conversation with Tammy Johnson, did you have an impression in your mind?
That my services would no longer be needed.
And so, can you give us a time frame? Would it have been before or after this April 25th, 2017 check?
After.
After. Now, can you tell the jurors, did you, prior or before you actually ended your employment with the MacGyver defense team, did you provide them with any advice or any counseling with respect to how to manage and communicate through this crisis? The defendant.
You know, I'm concerned about maybe some privilege issues here. How to be part of the defense team, and how where we're going with this, or how wide open this discussion is going to be.
Well, I'll lay some foundation.
Okay, maybe that'll help put some contours around it, and then we can revisit the concern.
Sure. Have you, Mr. Dickerson, you understand the nature of privilege with respect to representing clients? Yes?
Yes.
Can you explain it very briefly to the jurors?
My understanding of privilege is that when you work for in my world, clients will have me retained by their attorneys for the purpose of having attorney-client privilege. So the conversations that are had with clients and attorneys are privileged and protected.
Okay. In this case, were you hired by the attorneys?
I was not.
And so can you tell the jurors, with respect to your employment with the defendant, were you operating in your mind under a privilege?
I would say not. I would say that I was not.
Let me just be more direct. Let me ask you this. Did you become aware that the defendant, your client, had given an interview to Mark Winnie that occurred at the Fulton County Jail?
I became aware of that interview, yes.
Okay. And can you tell the jury, as part of your representation of the defendant, did you schedule that interview?
I did not schedule that interview.
Why did you say it like that?
Because I would not have scheduled that interview.
And why not?
Because I didn't think that it was an inappropriate thing to do under the circumstances.
Were you consulted about that interview?
I was not.
You were not. How did you find out about the interview?
I watched it on television.
And when you saw it on television, can you tell the jurors, what did you do?
I called one of his attorneys and I told them that I didn't think they needed my services anymore because they were taking their own media counsel. I offered to quit.
Okay. Now, can you tell the jurors, after the passage of some months, did you get the opportunity to actually see Mr. Howard?
Yes.
Can you explain to the jurors how that happened?
I was at an Atlanta Hawks game with a friend, and we encountered Mr. Howard. And the friend is a former neighbor rather, of Mr. Howard's, and Mr. Howard approached
And don't tell us what he said to you, but did you have a conversation with him at that time?
No, because he wouldn't address me directly.
And can you tell the jurors, can you give us a time frame about when would that have been? Are we still in 2017?
We're definitely in 2017. It would have been during the season of the Hawks and during sometime in the spring, probably around April or May.
Okay. And can you tell the jurors, was there another occasion in which you actually got a chance to not only see Mr. Howard, but have a conversation with him?
We had lunch
Okay.
in January 2018.
You had lunch in January of 2018.
Yes, sir.
And in January of 2018, were you working at all for the defendant?
No.
About how long had it been since you had had any contact with the defendant?
The defendant had been incarcerated.
Actually, Your Honor, let's not get into where he was. The question is simply, when you last had contact with him. And as I've told you all before, ladies and gentlemen of the jury, the fact that Mr. Mciver may have been in custody during some portion of the proceedings prior to trial is of no moment to what you need to work through. Folks get arrested, some folks stay in jail, some folks don't. It's not relevant in any way to the ultimate question you all are working through, which is guilt or innocence, and that burden, of course, is upon the state to prove, if it is able, Mr. McGiver's guilt beyond a reasonable doubt.
I reserve a motion for your time.
Sure. I think I just addressed it, but we certainly have preserved it, and we can talk about it.
Okay. Would it be fair to say that it had been several months since you had the opportunity to speak to or talk to the defendant?
Yes.
Okay. And the January lunch that you had with Mr. Howard, can you tell the jury, how did that get set up?
I believe that I received a phone call from the district attorney's office, his secretary, asking if I had a moment to speak with Mr. Howard.
Okay. And can you tell the jurors, do you remember what date that was?
I do not.
Okay. But you feel comfortable saying it was January 2018?
Yes, sir.
Okay. Now, can you tell the jurors, did you and I have a chance to see each other?
Yes.
And can you tell the jurors, when did that occur and where did that occur?
It occurred at the mayoral inauguration in 2018, January 2018.
Okay. And can you tell the jurors, did we have a brief conversation?
A very brief conversation, yes.
Okay.
We shook hands and exchanged pleasantries, and I mentioned that I was no longer on the case and expressed some relief.
And when you say you were no longer on the case, what case are you talking about?
The Mciver defense team.
And did you say that you expressed some relief?
Yes.
And can you tell the jurors, where did you have lunch with Mr. Howard?
Mary Max.
Mary Max, down on Ponce de Leon?
Yes.
And can you tell the jurors, was that the first opportunity that you had to have lunch with Mr. Howard in quite a while?
Oh, yes.
How was your exchange with Mr. Howard at that time?
It's just normal, and talking about different things, local politics and things of that sort.
Okay. And can you tell the jurors, during that conversation or during that luncheon, was that the first opportunity that you had had in order to communicate or tell him what it was that the defendant had asked you to do?
Yes.
Did you tell him?
I did.
And can you tell the jurors, what did you tell him?
Your objection. It's hearsay.
Okay, I just wasn't sure what the basis was.
I'm sorry, it's hearsay.
Okay.
What the witness told
Yes.
Mr. Howard?
Out-of-court statement being offered to prove the truth of the matter asserted.
Okay, I understand.
New era.
I understand. You're right.
Yeah.
Absolutely. How long did your conversation with Mr. Howard last?
Maybe an hour.
Okay. And let me see. Who paid for lunch?
I think he paid for his and I paid for mine.
And can you tell the jurors, was it sometime after that conversation with Mr. Howard that I had a chance to kind of meet with you at the office?
Yes.
I'd like to show you just one more exhibit. Judge, this is State's Exhibit 522. 522. Any objection? Yes. Okay. There being no objection, Judge, I would tender states 522 in evidence.
Whatever it is, it's admitted.
Let me have Mr. Dickerson identified. Could you tell the court what is State's Exhibit 522?
It's a check written out to Dickerson Communications.
Okay. It's a fourth check, right?
Correct.
What's the date on that check?
March 7, 2017.
And what's the amount?
$3,000.
And what account is it drawn on?
Estate of Diane Smith McIver, Claude L. McIver III, executor.
And do you recognize the signature on the check?
I do.
And whose signature?
Mr. McIver's.
Okay. Thank you very much, Mr. Dickerson. I believe that's all my questions, Judge.
Okay.
Yes. Oh. Thank you. Thank you. You did. Thank you. In front of the jurors, I'm saying thank you to Mr. Samuel and Mr. Harvey. I had shown them an exhibit, Judge, and had neglected to get it back. I wanted them to review it before I showed it to the witness. This is State's Exhibit 520. Can you tell the jurors, do you recognize and can you identify 520?
It appears to be a list of phone calls.
From whom to whom?
Well, there's an originating caller and a terminating caller, and Mr. Howard is listed, and I am listed, and Mr. McIver is listed. Stephen Maples. And I don't see any other individuals listed in this
Okay.
list of phone calls.
And you recognize the numbers contained on that exhibit to be phone numbers belonging to a phone that you had at the time of this communication with the defendant?
Yes,
And you see his number present as well?
I do.
You recognize Mr. Howard's number as well?
I don't recognize it. I don't recognize it because we don't have that many phone exchanges.
Okay. And how about Mr. Maples?
Mr. Maples is also present, but I wouldn't recognize his phone number.
Okay. That's Exhibit 521?
520.
I'm sorry, 520. Judge, I will tender 520, understanding that Mr. Howard's number, I believe, has been connected up through a prior witness. I believe Mr. Maples' number has been connected up as well, as has Mr. Howard's.
Mr. Samuel, any objection to the admission of 520?
I don't mind putting it at this point, but I'm not sure I agree with
Okay.
the representation.
And I'm making this vote because now I just checked Ms. Condor, she says Mr. Howard's number has not been connected up.
I would agree that that's my recollection as well. The others we've heard a whole bunch about, the
Right.
Maples and McIver numbers.
I just wanted to check to see if Agent Fitzgerald, I may have missed it, but I've been corrected, so I want to correct the record with respect to the Mr. Howard's number has not been admitted in the evidence yet, and subject to having that one line in the phone record redacted out, I would tender State's 520, Judge, in the evidence.
Okay.
No, I don't want to do that.
How about it's admitted provisionally, and we'll work through whether there's a stipulation as to what
Sure,
the phone number
sure.
is, or how that's going
Sure,
to work.
that's fine.
But I'll admit it provisionally, and,
Okay.
and we'll go from there.
Sure. And just so the jurors want to look at it, can you tell the jury what are the last four numbers for your phone?
1972.
Thank you. I believe that's all my questions, Judge.
Mr. Samuel.
Dickerson. My name is Don Samuel. I don't believe we've ever talked that way or met.
I believe we have.
Do we have?
Yes.
And I'm embarrassed. When did we meet?
In your office.
In my office?
Yes, sir.
When did we meet in my office?
With another party.
Some other case.
Not a case. Not a case. Just things related to your office.
You know the lawyers in my firm or something?
No, the meeting was with you, but that's okay.
Bad way to start. I thought that was an easy one. I'm going to try again. Good morning, Mr. Dickerson.
Good morning,
There we
Mr.
go.
Stetson.
Now I feel much better. This is going to go real smooth. Mr. Dickerson, let me get a little bit of a timeline here. Sometime in December of 2016 is the first time that you had contact with Mr. McIver, is that correct?
Yes.
Okay. And just from the phone records, I just noticed that Exhibit 520, that you also had a phone conversation with, it looks like from the record, with Paul Howard in December of 2016 that lasted 10 or 15 minutes. You got the exhibit up there. You see that's like the first one on the ledger there?
It is.
Okay. So you had a phone conversation with Mr. Howard of, how many minutes is it? Would you mind telling us the elapsed time?
18 minutes and a second.
Okay. 18 minutes and 1 second in early December 2016.
December,
Yes.
December 6th.
Of 2016.
Correct.
And then you end up getting a phone call from either Mr. Maples or Mr. Hill, who were the two defense lawyers at the time, correct?
I received an email from Tammy Johnson, I believe on either the 26th or the 27th of December.
Right after Christmas.
Yes.
To go meet with the defense lawyers and agree to meet with them over at Steve Maples' office in Decatur, correct?
Correct.
And you meet with them and either in the presence of the lawyers or alone at some point, you're in a conference room and Mr. McIver describes the facts of the case to you, correct?
Yes.
Correct?
Yes.
And what he says is that they're driving on I-20, they get off at Edgewood, correct? Coming back from the ranch,
He
right?
seemed unsure what the exit was, but yes.
Okay. And he was fearful, he woke up at the bottom of the exit ramp, right? You need to say yes or no for the court.
Yes.
Okay. And it was at that point that he asked Diane, who's in the front passenger seat, to give him his gun, correct? Give him the gun that was in the console, correct?
Correct.
And it was in a Publix bag, right?
It was in a plastic bag as it was described to me.
Okay. And either then or some subsequent time, he said that's because he figured if the gun remained in a Publix bag or a plastic bag, that if someone broke into his car, it wouldn't be readily apparent that it was a gun in it, correct?
Correct.
And they're driving away from that part of Atlanta, correct? And get on Piedmont and start heading north, correct?
Yes.
And he tells you that he fell back asleep, right?
Yes.
And he got to wherever it was, 12th Street, 14th Street on Piedmont, and he's awakened by the flash and the noise and the gun going off, correct?
Yes.
And even though you're not a lawyer, having heard from him, you thought maybe you would go to Paul Howard and be able to talk him out of this case, right?
I felt that I could, even though I am not a lawyer, and because I had a relationship with Mr. Howard, a friendship I would call it, that I could convey to him information that Mr. McIver shared with me.
He had lawyers, right? He had William Hill is one of his lawyers, correct?
Not at the time. The only lawyer that I knew of at the time was Mr. Maples.
Okay. And and you told Mr. McIver that one of the reasons he may want to hire you is because you have such a long-standing 30-year relationship with Paul Howard, correct?
I did tell him that I had a long-standing relationship with Mr. Howard.
Which goes back, at least according to one thing I read, about 30 years.
That's correct.
Okay. You knew him when he he was an assistant DA, like these folks, at one point in the DA's office. Then he went into private practice, like three of us over here. And then he was running for solicitor when you met him back in the mid-'80s, correct?
That's correct.
And you've known him ever since.
I have.
And you've met with him many, many times over the years.
I have.
Sometimes professionally, sometimes personally. Friendship, right?
Mostly friendship or personally, but a few times professionally, yes.
Meaning either working with another defendant at some point or something else that was in the DA's office's jurisdiction, correct?
Correct.
And now let me, and Mr. McIver agreed to hire you.
Yes.
Okay. Your credentials, your background, your knowledge of Mr. Howard all, obviously made it seem to him worthwhile to have you part of his defense team, correct?
Correct.
You knew at that time that he hadn't been indicted by the grand jury, correct?
I'm not sure.
He'd been arrested and charged, correct?
Yes.
And what he was charged with was involuntary manslaughter, correct?
Correct.
And it was predicated on the thought that it was reckless conduct, right?
Yes.
And there was no charges of obstruction of justice at that time.
No.
There were no charges of influencing a witness at that time.
No.
No charge of aggravated assault or felony murder or malice murder, correct?
Correct.
It was just, your understanding was one count of involuntary manslaughter, unintentional killing, correct?
Yes.
Okay. And Mr. McIver said, in essence, will you help me either get the charge reduced or eliminated altogether? And yes?
Yes.
And he described the facts of the case to you, correct?
Correct.
And you said you would go talk to Paul Howard, and that was really about all you had to offer, wasn't it?
Well, there was a tremendous amount of media interest in the case, and so I had that to offer as well.
Right. Well, okay, so let's turn there. The media coverage was something that was engendered in large part because of this representation made by Mr. Crane, you know about that, about the reason that he took the gun, asked Ms. McIver for the gun at the bottom of the exit ramp, whatever it is, was because there were people milling around, maybe carjackers, maybe homeless people, and maybe it was a Black Lives Matter protest, right?
Correct.
That had engendered a firestorm of media, correct?
That's correct.
And it was sometime in December of 2016 that the defense team said, Mr. Crane has not been serving us very well, correct? We're going to hire Mr. Dickerson to help us get out of this media problem, right?
I suppose.
But when you met with Mr. McIver, in addition to dealing with the media problem, it was also to try to get the charge, it was just a charge at that point, reduced or eliminated, correct?
Correct.
Because you could go talk to Paul Howard and do it, right?
I don't know that they knew that ahead of time. I offered after hearing the story.
Say it again?
I said I don't know that they knew that I had that relationship ahead of time unless someone told them that.
Okay.
I offered to do it after hearing the story.
Okay. So let me talk to you a little bit about the nature of a success fee, as you call it, okay? This is something you do with many of your clients, correct?
Some.
Okay. And a success fee, sometimes lawyers refer to it as a contingency fee. Have you ever heard it referred to as a contingency fee?
Only with lawyers.
Okay. So we call it a contingency fee. In your business, you call it a success fee, right?
That's correct.
Okay. And just to kind of boil it down, if you hire me and I achieve the result you want achieved, you will pay me extra, right?
Correct.
It's like a baseball player who may get a contract of $6 trillion a year, but if he gets 60 home runs, he gets 100 trillion, right?
Correct.
Okay. If I do well, if I just do the work that I say I'm going to do, I get my $3,000 a month. But if I succeed, I get more, right?
Yes.
It's a bonus.
It is.
And you call it a success fee.
Yes.
And Not unusual in your business, as you said.
Not unusual.
All right. Sometimes it's in the contract, sometimes it's just understood.
Usually it's in the contract, but sometimes it's just understood. That's correct.
Okay? And as I understand it, in this case, you talked about a success fee with him, but never actually reached a number.
That's correct.
And yet, when you met with Mr. Rucker, I think you said you met him in the office here, you said, had I succeeded, I would have taken the money and deposited it in my bank account.
Yes.
Correct?
Correct.
But there was no number yet at that point.
That's right.
Okay. But had, and I know this is all hypothetically, if I had met with Mr. Howard, and if I had, in fact, convinced him that Mr. McIver was not guilty of any crime, I would have expected Mr. McIver to pay me extra, correct?
Correct.
And that was the success fee, right?
That was his offer. Yes.
And you're not talking about going to trial and winning, right? Because you're not a lawyer.
Correct.
You're not talking about filing a motion where the judge says, I'm going to dismiss this whole case, because you're not a lawyer, right?
Correct.
It was just to go talk to Mr. Howard and see if your persuasive ability, and at least by that point, Mr. McIver knew who you were and your relationship to him. If you could talk Mr. Howard out of it, you get a success fee, correct?
That was the understanding.
And I think I've asked this, but from kind of a different angle, you've not been arrested for murder at that point, right?
Correct.
So this conversation, as I understand it, you said was December, well, I wrote down December 27th, but maybe it was the 28th, is that what you said? Somewhere in that neighborhood, within a day or two of Christmas.
Yes.
And it was in the Steve Maples Law building.
Correct.
Okay, maybe it was a shared conference room with other lawyers, but in the law firm. At the law firm building.
At the law firm building, or at the office building.
Indicated.
Indicated.
And one of the things that you talked to them about, you talked about the bad press that was kind of spiraling out of control, and it had already spiraled out of control with Black Lives Matter, right?
Yes.
The other problem was this auction that was occurring, right?
Yes.
That was also engendering bad press, right?
Correct.
There was an auction of some of the property belonging to Diane McIver, right?
That's correct.
And you told them that you're getting terrible press. It just looks terrible that this property is being auctioned, right?
Correct.
And Mr. McIver said to you, well, okay, but the problem is there's a penalty if we cancel the auction. Remember him telling you that?
Yes.
Okay. So even though you said this is a bad idea, it's just the optics are bad, right? What it looks like is bad. He said, I can't change it now because there's a cancellation fee, right?
Well, first he said, I'll change it, and then he found out that there was a cancellation fee, and he changed his mind.
Okay. And did he tell you who had told him that he needed to do the auction to raise money? Did he talk about the probate lawyers that were representing him?
My understanding at the time was that he needed or wanted to raise the money to satisfy the terms of Mrs. McIver's will.
Okay. So your understanding was that the will required that certain money be paid upon her death, but you need cash to do that, right? From the estate.
Correct.
Sell the property in an auction, raise the cash, pay the bequests, correct?
Correct.
So again, hypothetically, if the will says give John Doe $100,000 and the estate doesn't have a bank account with $100,000 in it, the theory is you sell some of the assets of the estate, generate $100,000, pay John Doe, so John Doe at least has been paid, correct?
Correct.
Okay. And that's what he expressed to you was the reason for having the auction, correct?
Correct.
And you said, nevertheless, it doesn't look good. You got Black Lives Matter bad press. You got this bad press. If I'm your press guy, you got 2 strikes against you already. It has nothing to do with the shooting, right?
has a lot to do with public perception.
Public perception. That's what the focus is, the public perception, right? That's what your job is.
Yes.
I think you said at one point that it was, your job was, it was paramount how people viewed him. That's a question.
I probably said that, yes.
Can you tell me how many times you met with Tex Mciver in person?
I can't. Maybe a half dozen times.
And that's between
Outside of the courtroom?
That's between December 27th and sometime in April.
That's correct.
Now, Your Honor, excuse me one second. Who drafted the language in State's Exhibit 519, which is the letter agreement?
I would have drafted the language.
About all the different things that you're going to do for Mr. McIver, correct? Was there ever a time that you had talked about having your agreement with the estate as opposed to Mr. McIver personally? Do you remember any discussions or drafts of this agreement in which the contract was with the estate as opposed to Mr. McIver personally?
Yes. I remember there being some conversation about submitting another agreement with the estate. Yes.
There was going to be two agreements?
Naming the estate, that's correct.
And was the idea that the estate was getting some service and Mr. McIver was getting some service from you and they would split the $3,000 or something like that?
That was my understanding, yes.
Okay. So do you know if you have a copy of a second agreement in which it was $1,500 for the estate and $1,500 for...
I think I neglected to draft that agreement and to get it to Mr. McIver.
Let me show you what I tentatively marked as D14.
Oh, okay.
Does that refresh your recollection of
It
that?
does. It does.
Okay. Would you have drafted D14?
I would have, because it's just boilerplate language primarily.
I'm going to tender D14.
Any objection?
No.
B14 is admitted.
It is, in many regards, I'm not going to go word for word, essentially the same as State's Exhibit 519, except instead of being an agreement with Mr. McIver, it's an agreement with the estate to essentially provide the same service, correct? Am I right?
You are.
Okay. And, you know, to be fair, it was never signed, correct?
Correct.
Page 2, I'm kind of showing sloppily on the screen here. This one was never signed, so it was an idea, it was a draft, but you ended up just receiving the $3,000 per month from, based on the one contract that's
It was, I remember it being requested. I didn't recall actually changing the language.
No problem. And you got but you didn't get a retainer, but you just $3,000 a month.
I think that there was a retainer.
There was a retainer, 7,500 retainer?
I don't recall if it was 7,500.
All right. You told the, what do I have, Judge? 10 minutes?
You've got 5 minutes. You have as much time as you want.
No, I know that,
We have to stop at 12:20. That doesn't mean you need to stop before then. We will stop at 12:20, and if you have more you want to ask Mr. Dickerson, we'll do that after the break. So don't feel governed by that. But then 12:21.
Well, I was just wondering that apparently the appropriate language is pivoting, and if I said the word pivot, apparently I have some control over your calendar. I did not realize
You get
that.
to try that out if you present a case, but that's apparently a direct examination technique.
Got it. Same with the good morning business, right? So, the conversation in Mr. Maple's office happens on December 27th, 28th, okay? You gotta say yes or no, I'm sorry.
Sometime in late December or early January, yes.
And you, at some point, send a text to Paul Howard that in essence says, I've been hired, I've got a new case. Apparently you didn't even mention the name, right?
I did not.
Maybe because you figured without a name, you'd at least pique his curiosity and he'd write back to you. Whereas if you said the name, you kind of spilled the beans too early, right?
That's correct.
So you tell him I have a new case and he calls you and whatever the conversation is, or texts you back?
No,
Well, I thought,
he didn't call me. He responded in a text message.
okay, he sends you a text back, who is it? You respond, and after that, as you put it, crickets, right?
Correct.
And what crickets means is silence.
Correct.
I knew it was.
Right.
And so, when does that text exchange occur? Have you been able to go through your phone and find the date of that text message?
I have not. I don't keep those text messages in my phone for that length of time, but it would have been in January 2017.
Right. Well, the reason I'm asking is because your contract is January 3rd.
Correct.
Before or after?
After.
So you sign a contract on January 3rd, and thereafter, you send one text message without saying who the name is. You get a response back who you respond by text message, Tex Mciver, that's it.
Correct.
What is the date of the first time you get a check? With the signing of the contract, you think?
I think it would have been the signing of the contract.
And that would have
yes.
been the retainer?
I would think so, yes.
And do you bill against the retainer, as we said?
Yes, for that first month.
So, there's the retainer is $7,500, right?
Really not sure.
Well, it says, look at your contract.
I see what the contract says, but I'm really not sure because we negotiated the terms and I just don't remember if it was 75,000 or some lesser amount.
Hopefully 7,500.
7,500. I'm sorry. Or some less than that, or some lesser amount.
But my question was actually maybe not clear. The agreement was a $7,500 retainer.
Yes.
That's in the contract.
Yes.
Whether you got it that day or subsequently. And the way a retainer works is you get paid, and then, at least in theory, at least, the next 2.5 months they don't have to pay you because you've already been paid up front, the $7,500, right?
No, that's not the way it works in my business at all. There's just ordinarily an awful lot of work to do initially.
Well, you're not being paid by the hour, are you?
I'm not.
So what's the $7,500 retainer for?
Well, the $7,500 retainer is for just delving and immersing oneself into the project, whatever the project happens to be.
Okay, so you're actually getting $3,000 a month and $7,500.
That's correct.
Yes. The $7,500 is not,
It's
down,
not. It's
down payment on the $3,000.
It's not a down payment on the $3,000.
Got it, okay. So you're getting $3,000 a month in addition to the initial retainer.
In addition to one initial retainer, that's correct.
The conversation that occurs, Your Honor, you're going to give me 7 minutes, right? That's the most I got.
You're gonna have 3 hours, we're just breaking at 12:20. And so unless you have a really, really long question, you can ask a few more and you'll get answers. And then I'm not gonna cut you off mid-sentence. I'll say, okay, now let's take a break.
I have a sense that we're going to come back from lunch and I'm going to have 3 minutes to go, but I'll do the best.
That's not how it works.
That's my timing. You had this meeting in the conference room now we're back to the 27th, the first meeting, correct? Say yes or no, please.
I do not believe that our first meeting was on the 27th. I was initially contacted on the 27th.
Every time I say 27th, just assume I mean within a couple days of Christmas, all right?
Okay.
I'll continue to make the mistake, and you just 27th, 28th, 29th, somewhere around there, right?
Yes.
All right, I'll make it the 28th for now. And there's that's when he talks about the success fee, right?
I am not sure if that is the conversation where we had a conversation about the success fee.
You're not sure about it?
No, I'm not. On the 27th, these records indicate that Mr. Mciver and I spoke on the phone. We had a subsequent initial meeting at Mr. Maples' office, and either at that initial meeting or at the time of the signing of this agreement on the 3rd, that's when we had the conversation.
Okay, when you
about it.
testified to Mr. Rucker that it was the first meeting at Maples' office on the 27th, 28th, is that not correct?
Well, I've tried to be as clear with Mr. Rucker and his team as possible that I don't recollect the exact date, that it may have been the first or second meeting with Mr. Mciver.
So it may not have been the first meeting, it may have been the second meeting, and that meeting also occurred at the law firm?
Yes.
And also in the conference room?
Yes.
And that's on the day that the contract is signed, which is January 3rd?
Quite possibly, yes.
Well, was there a third meeting?
Well, there was a third meeting, but there wouldn't have been a third meeting where that would have occurred. It was either at the first or second meeting where this conversation took place, this exchange about a success fee.
And he doesn't say anything to you about cash, correct?
No.
There's no agreement as to an amount of money in the success fee.
Correct.
He says you can share the money with anybody you want to, right? And you ask for clarification, right?
Correct.
He didn't say to you, offer Paul Howard money, did he?
No.
He didn't say, tell Paul Howard there's money in this for him. He'll dismiss the charges.
He did not say those words.
What he said to you was, there's a success fee for you, and you can share the money with anybody you want to, right?
That's correct.
And you asked him to clarify,
I did.
because you didn't know he was talking about, whatever, Mr. Maples. I don't know why Mr. Maples would get it, but, or anybody else,
Could have
right?
had another communications firm. Could have
Maybe
been.
he owed Mr. Crane money or something, if you wanted to share it with him. It was up to you. Right? That was the question. It was up to you to share anybody you wanted to. He wasn't telling you who to share it with, right?
I don't think that he was telling me anything other than if you can get the charges reduced, there's a success fee in it.
And you can share it.
Well, I wanted to be able to finish his answer.
Yeah, you've been talking over him a little bit. Zeal.
his words to you, which you expressed over and over, both on direct examination
Can I
and
answer before we get to another question?
He was mid-answer when this came up.
Finish.
You may have now forgotten what you were talking about. Did you have more you wanted to say? Okay. All right.
Finish the answer together.
Say again?
I said, I think you and I finished the answer together.
You can share it with whoever you want to. Okay. And you took that to mean you could bribe Paul Howard if you wanted to.
I didn't take it to mean that. I asked for clarification because I thought that it was an odd thing to say, and I didn't know who he was talking about. And so I sought clarification.
And he said, including Paul Howard.
He did not.
Go ahead. What did he say? The DA?
His words left me with the distinct impression that he was asking me to share this amorphous success fee with Paul Howard. I hadn't offered to reach out to anyone but one person, and that was Paul Howard.
That's the impression you formed?
That's correct.
Huh?
That's correct.
You didn't say, offer Paul Howard $5,000, $10,000, tickets to the Hawks game, nothing.
No monetary amount was ever discussed.
You never said anything about cash.
No.
He didn't tell you to tell Paul Howard that there would be money if the case was dropped.
He couldn't have. He could not have. I would not have.
I'm asking what he said to you. Mr. McIver never said to you, tell Paul Howard if the charges are dropped, there'll be money in it for him. Did it?
No.
Or that there be a prize or a reward or a gratuity or anything. He didn't tell you to tell Paul Howard that.
Not with any degree of specificity, no.
That was your impression.
That's correct.
You thought it was a stupid suggestion and you told him so, didn't you?
I did.
You told him that's stupid, not going to do it, and forget about it, right?
I didn't tell him it was stupid. I told him that I would never do such a thing and that the district attorney would never accept it.
And he never said a word to you about it again.
That's correct.
In the history of mankind, since that day, he never said it again.
That's correct.
And you didn't go and tell Steve Maples about this impression you had.
I did not.
You didn't tell the new lawyer who came in shortly thereafter, Mr. Hill, about this impression you had.
I did not.
You didn't tell, you didn't call any detectives you're good friends with and tell them, you're not going to believe what just happened in Steve Maples' conference room, did you?
I'm not good friends with any detectives, but no, I did not.
And you didn't call Paul Howard and say, Paul, buddy, Mr. McIver, my impression is, just said I could share money with you. You didn't call Paul Howard either.
I did not.
And never again did Mr. McIver mention this to you, or did you mention it to Mr. McIver after January 3rd or December 28th or whatever?
I'll object, Judge. I let him ask a few, but I think we established, yeah.
History of mankind. Next question.
That's a pretty long history. All right. You didn't rip up the contract.
I did not.
You didn't say take your money and go drop dead. I'm not going to represent you anymore.
I did not.
You didn't tell the lawyers I'm going to have nothing more to do with this case.
I did not.
You didn't have any problem accepting the $7,500 and the $3,000 a month for the next 5 or 6 or 7 months, however many it was.
That's correct.
Did you tell him, I think you told Mr. Rucker, I sent a text to Paul Howard, you talked about this, and there was no answer. You told him that he was disappointed, wasn't he?
Yes.
But he continued to pay you, or the state paid you, that you continued to get the $3,000 a month, correct?
Correct.
And the first time it comes to light is approximately a year later, correct? At Mary Mac's restaurant.
Correct.
Paul Howard calls you, right? and
Yes.
says, let's go have lunch at Merrimack's.
Yes.
Is that a common place that you all would go for lunch?
It's a common place that he goes for.
And you said to Mr. Rucker just now, that's the first opportunity you had to talk to him?
Opportunity to talk to Mr. Howard?
Yeah, that's what you told Mr. Rucker a minute ago.
I don't know that it was necessarily the first opportunity. It was just the first time that we talked since I'd worked on the Mciver case.
You could have called him any time for 12 months if you had something that you needed to tell him, as opposed to just doing some lobbying or discussions, right?
No, I don't believe so. I think that Mr. Howard was under the impression that I was working on this case and was not willing to talk to me for that length of time.
If
But
you
I was
wanted-
engaged.
If you wanted, I'm sorry, if you wanted to report your,
Not with the time. Just things like that.
And did not want to talk to me while I was engaged.
if you wanted to report your impression, you could have called him, you know Clint Rucker, you could have called Clint Rucker, right? You've known Clint for decades, right?
I've known him for years, yes.
If you wanted to report your impression, you could have called him, right? But you didn't do that either, did you?
I did not. I saw no reason to.
Okay. Fair enough.
I just wondered if you're done. If you're not done, that's okay. I'm done. All right. Ladies and gentlemen, we are going to break for lunch. As I mentioned, it's going to be a little longer than usual. If you all could be back by 1:30, we'll do our best to get you back in here a little bit after 1:30. We'll see if there's any redirect of Mr. Dickerson, and then see if there are any juror questions. During lunch, enjoy yourselves as a group, individually. Don't talk about the case, no outside research. And I think we'll be seeing the state rest this afternoon. I'm hearing on good info. We'll see where we go from that. All right? Thank you.
All rise for the jurors.
Mr. Dickerson, I'm sorry we're going to delay you a little bit longer, but we do need you to be back here at 1:30. Between now and then, please don't talk about your testimony with anyone. We'll see you back right around there, around 1:30. Thank you. See you guys at 1:30?
Yes, sir.